Welcome to Legal Innovation Spotlight, the podcast that brings you the latest advancements in legal tech and knowledge management. I'm Ted Theodoropoulos, and I connect with the industry's brightest minds to provide you with valuable insights and actionable takeaways. So sit back, relax, and let's dive in. Catherine and Tim, how are you today?
Very well, thank you.
Good. Well, I appreciate you guys joining me. This conversation was a result of pseudo partnership with PLI and Patrick Dundas on this mammoth of a book here. I call it the KM&I Handbook, but handbook actually is not in the title. It's Knowledge Management and Innovation, a manual for law firms and other legal services organization, or KM&I Handbook for short. And you guys wrote a chapter in here, and as part of this series, I'm talking to folks who contributed to the book, and you guys had a really interesting chapter, at least really interesting for me. I'm a Lean Six Sigma black belt and did process engineering work at Bank of America for many years. So this really spoke, and did a little bit of this in the law firm space too. You guys are really doing some interesting stuff at Mayer Brown that we want to talk about. But before we get into that, why don't we just do some quick introductions? Catherine, you've been at Mayer Brown quite some time. Why don't you kick us off, and then Tim can introduce himself.
Sure. I've been at Mayer Brown since 2005. I was at another giant law firm before that, and I'm a litigator. So I was, a fee-earning litigator for a great many years, sort of focusing on litigation involving financial services and financial products. And then we created a knowledge management department here at Mayer Brown. And the way it's set up is we have sort of embedded subject matter experts in a lot of the practices, plus a central team. And so I am the knowledge management lawyer for the U.S. litigation and dispute resolution practice. So I advise and support the practice in a number of ways, by teaching, by sending out bulletins, by creating forms, isolating samples, learning tech tools, and so on. It's a really enjoyable job. I've really been happy doing it.
Stuff. Tim?
Yeah, and I joined Mayer Brown in 2020, 2 weeks before we were all sent home for the pandemic. So kind of an interesting time to join the firm. Initially in a process role, and then after a year's time, transitioned over to KM. And it's really been a fantastic trip. I'm an operations manager within the KM group. So I manage a lot of sort of our data and systems back end, things like our electronic closing binder process, our global knowledge bank. And then I work closely with our innovation team and with our professional support lawyers like Catherine on initiatives that are more practice and client facing. Prior to Mayer Brown, I was with Hogan Lovells for about 2.5 years in a consulting and operations role, primarily setting up a service center for business services. And then prior to that, I was in industry since 2009 when I graduated. Worked in consumer products, worked for a health insurance company, and then made the jump to legal. I am an MBA. I am Lean and Six Sigma certified, but I'm also a lawyer. And like Catherine, I do pro bono work primarily in the asylum space.
And you have a last name that's might be even more difficult to pronounce than mine. Pronounce that for us.
Krzywisseau, we think. And there's a story behind that. I think I've told Catherine this. I'm actually Polish by name lineage. My wife is French, but when we married, we actually combined our names, like literally did a legal name change. So our name is a mishmash of our two names, which is why it looks partly Polish and partly French.
Wow. That's interesting. So I'm Greek, and my full name is Theodore Theodoropoulos. So it's, and a lot of Greeks, they do the opposite of kind of what you did. They lop off usually the Opolis, but then I would be Theodore, and that wouldn't make sense. So I'm stuck with Theodoropoulos. Well, let's talk a little bit about what you guys wrote about in the chapter. So when I read this, we did back when we were consultants, we used to be called AcroWire before we were InfoDash, and we used to do time and materials consulting, mostly in the technology space, but we did a really big, long process improvement gig at a default services firm in the late 2000s, like 2009, 2010. I think it went on probably until 2012. And they have a very predictable workflow. Foreclosures are very process oriented, as you can imagine, just like immigration, just like intellectual property. It was a amazing engagement. We put TVs with control charts and process status on the floor. It was really almost run like an assembly line, which I had never seen in a law firm before, and really haven't seen it since. ABA Journal wrote an article about it. It was a lot of fun and cool. When I first talked to you guys and you told me you were doing this in the litigation space, it was like, all right, I thought that would be the last place that you could really apply process mapping, and process mapping is the first step to process improvement. I thought that would be the last place, practice area, you could do it, just because things are so dynamic and unpredictable. But Catherine, it sounds like your experience as a litigator, and you combine that with your process improvement training. And why did you start with litigation?
Well, I started with litigation because I am a litigator and an experienced litigator. And having done this now for 21 years or so, I know that there are conventions and rules and patterns in every litigation. Obviously every litigation is different. Here at Mayor Brown, we do pretty high stakes innovative litigation, but you still start with, if you're a plaintiff, the complaint, or if you're a defendant, one of many responses trying to get rid of the complaint, or at least minimize the liability it tries to impose on you. And then, you proceed through different stages of the litigation. So I think that litigation is as susceptible to process mapping and process improvement as anything. It different types of litigation or different types of processes can get more and more granular. So you just have to figure out the level that serves the process that you're trying to improve. We can't get super granular with litigation, right? Not as much as you could with, say, foreclosures. You're not going to produce the same document with minor changes over and over and over again. So we had to get a little bit higher, but still you can provide people with a roadmap of how a litigation generally goes with various options and links or directions to various resources.
And how far downstream can you take this? Are you just met, like, for example, in the foreclosure world, the immigration world, the intellectual property world, you can map it from cradle to grave, right? It's fairly predictable. There are a finite number of paths that these matters typically take. How and Tim, maybe you can chime in on that. So, like, how far downstream are you guys just mapping the first, 4 or 5 steps in the process, or are you also going cradle to grave in the litigation space?
Cradle to grave, really. I mean, if you have a federal civil litigation, you have to operate by the federal rules of procedure, which give you a number of, but a limited number of ways you can go. So if you are a defendant and you get a complaint, right, there are a number of mechanisms that the federal rules allow you to use to reply to the complaint. If you get past that stage and move on to discovery and fact finding, there are a certain number of mechanisms that the federal rules allow you to use. You don't get to go outside of that. So, internally, and there's a excerpt of this in the book, we've created a commercial litigation process map that starts actually before a complaint, with initial case assessment, and goes all the way through appeal and final resolution of the litigation, and then links to various resources that are of use, internal and external.
Okay, so I guess just from an outsider's perspective, it seems like it could go a million different directions, but you guys are much closer to the work, and obviously know better. So Tim, you're Six Sigma trained, and when I first started reading the chapter in the book and saw, like, well, first of all, just Lean Six Sigma. Lean and Six Sigma are not the same thing. They actually have very different objectives. Lean is about eliminating waste, and Six Sigma is about um, eliminating or reducing defects. And then they've kind of come together to provide a framework for doing a little bit of both. But like how foreign a concept, in terms like DMAIC and downtime, and like do you discuss do you use these terms in with attorneys, and do you get funny looks when you do?
Not so often. You do run into the occasional associate or partner who has maybe a non-traditional background, and non-traditional meaning they didn't just come from kind of wanting to be a lawyer their whole life. Some of them came from maybe the tech industry or had a process role in their past life. So sometimes you can kind of find that middle ground, but often you kind of stay away from terms like that. And there's a lot of training involved in my experience on what process involves. You highlight the difference between Lean and Six Sigma, and that's really a key difference. Six Sigma requires a whole lot of data, and it's about process control. Most people, when they say process, they have an idea that's closer to Lean, which is what I find we use much more in at least the law firm space. How do you cut out the waste? How do you identify the decision points? How do you separate the judgment, which is why a lot of people think it's impossible to process map legal, from the actual process you're doing? Because people follow a process or make up a process, whether they realize it or not. And I think what Catherine's done, which has been really great, is kind of map out the process, but then also have those judgment points within the process. So when you're doing motions practice, when you're evaluating a case, that's where having the legal expertise comes into play. Once you've exercised that judgment, then you go down the path that's most appropriate. The two can coexist. And I think when people picture legal and think it's difficult to apply process to it, it's because they're conflating that legal judgment with the fact that you are going to have some sort of process that's layered on top of it.
Yeah, and so I came from a you guys do a great job kind of laying out the roots of Lean Six Sigma, and its origins are really back from the Motorola days in manufacturing, and it's really easy to visualize how Lean and Six Sigma would apply there. But I learned it at Bank of America in financial services, and there were a lot of head scratching when I would tell people what I did there as well. But just like legal, you have processes. For example, when you walk into a branch and you make a deposit, Six Sigma has a concept of DPMO, defects per million opportunities, and I think 3.4, if I remember correctly, that number gets drilled in your head. That's if you can achieve 3.4 or less defects per million opportunities, you've achieved Six Sigma objectives. And if you walk into a branch and you make a deposit and you walk out, did the right amount get applied to the right account? Was the right name? Were there any anti-money laundering processes that should have kicked off? Did you deposit more than $10,000 in cash, and a currency transaction report should have been filed? All of these sorts of things. So, when you break it down, I guess you could probably apply. There's probably more places or fewer places that you can't apply Six Sigma than you can. Would you agree with that, Catherine?
Yeah, I would. One point we make in the book is that Lean Six Sigma, and we go into its origins, the origins of Lean, the origins of Six Sigma, and then the origins of Lean Six Sigma, is that they're all just mechanisms from getting from A to Z, right? And they're useful because they yield tools that you can use to examine and improve processes. And it doesn't matter what you call it. You can use Lean Six Sigma tools and methodologies without calling it Lean Six Sigma if we decide that's better for the attorneys, which, frankly, it probably is. But they're all, they're useful. There's one called the 5 questions, right? Where you take a problem and then try to get to the root of it. in 5 questions. We have an example flowing throughout the chapter about a partner who asks a junior associate to draft a protective order, which is a pretty garden variety routine litigation document in which the parties agree what's confidential, what's not, and the format in which documents should be produced. But the partner doesn't give the associate any guidance, and the associate tries looking for some samples and can't, and then ends up spending basically 25 hours drafting this order. And it's not what the partner wants or what the client wants. So the partner has to ask a senior associate to work on it. And then the client is mad because they see 25 hours spent on this and then more expensive senior associate time. So the problem is the client is mad. And then you drill down, say, why is the client mad? And the answer is because they billed all these hours. Why'd they bill all these hours? Because the product wasn't good enough. Why was the product not good enough? The associate had no experience and had no tools. Why is that? Because the firm didn't have a CAM function or didn't have a well organized sample bank, or had those things but didn't effectively communicate their existence and how to use them to the associates. So you drill down, and that answer is a process answer, right? It identifies something that the associate should have had available and should have been able to use in the process of drafting this document, getting it to the partner, and then getting it to the client.
Yeah, we used to call, when I was being trained, the 5 whys. And, the example I think they used when I was going through training was at the Lincoln Memorial. I don't know if you guys have heard this example, but the Lincoln Memorial was, the stone was deteriorating rapidly, and it was bird poop was the problem, and they're like, okay, how do we get rid of these birds? And they started applying kind of the 5 whys. Well, okay, the birds are the reason why the stone is starting to deteriorate more rapidly. Okay, why are the birds there? Well, the birds are there because they're eating bugs. There's more bugs than normal in this particular area. Okay, well, why are there more bugs? Well, because the lights that shine on the Lincoln Memorial at night attract the bugs. So, what started off as how do we get rid of these birds became as simple as let's turn the lights off at some specific hour to reduce the bug population that drew the birds in. So, yeah, it's a great principle to apply because, doing root cause analysis a lot of times gets glossed over, and you end up addressing issues that really don't drive the outcome that you're looking for.
I just realized that it is in our book, The 5 Whys, and I said the 5 questions, which
mm,
of course is what the youngest person at the Seder has to answer. We just had Passover, so that was probably on my mind. So sorry about that, fellow Jews.
all good. Well, and you guys, speaking of terminology, I have not really heard the terms LPI and LPM. When I think LPM, I think legal project management. And well, actually, yeah, that's what you're referring to here in the book. Like, maybe you can explain LPI and you differentiate with LPM. Tim, I don't know if that's somewhere you want to jump in and give us some context on the difference and why you kind of highlight those terms in the book.
Sure. So LPI, Legal Process Improvement, was the name of the team that I initially joined. But I will say there's a term that's coming into currency lately, LPI being Legal Practice Innovation. And we actually have an LPI team that has that moniker now. So clarification there on terminology. But yeah, LPI is really trying to meet the practice where they are and to bring some of the methodologies that we've introduced in the chapter and that Catherine's mentioned and you've talked about to improvement of legal processes. Let's first of all acknowledge there's a process, and then talk about ways of improving it, either for better client outcomes or for increased profitability or increased efficiency or whatever the objective might be. There are tools that we can apply to that. I will say as well, though, that the term process seems to be losing a bit of prominence in my personal experience anyway. There seems to be a shift now toward design thinking. And I really think that gets to what you mentioned earlier, Ted, that you're trying to address root causes. And often root causes come down to human behavior. And human behavior is kind of driven by the design of things, right? So if we think about kind of outside the box, what should the design of this be? Often that's a better endpoint and a little bit easier to open up discussions with fee earners, for example, than talking about process, which really comes from the manufacturing world and has a lot of sort of esoteric knowledge that needs to come with it. So minor nuance there, but yeah, LPI would be legal process improvement, again, with this sort of design thinking flavor that's been coming in more and more from innovation teams.
Yeah, if I can add on to that, my mantra for any kind of process improvement tool is that there's three parts to it. One, it has to address a real life problem that lawyers have on a regular basis. Two, it has to solve that problem. And three, the learning curve has to be as close to zero as possible, which is where design thinking comes in. So when we were designing our process map, that is what we strove for, right? The problem is that constantly having to reinvent the wheel. To find drafting a motion that someone's drafted a billion times, but you don't have one on hand. Then providing the solution, which is samples and guidance, and doing so in a way that someone can look at it and immediately figure out how it works.
So I think I saw both your heads nod when I said there are probably fewer places that can't be where you can't apply these process improvement methodologies than where you can. Where in a law practice, if anywhere, do you think it would be difficult or just not viable to apply these?
Hmm.
I think it's easier to answer the opposite question.
I know
it
is. It is. Yeah, because it's almost everywhere.
I guess research memos, right? I mean, you could provide someone with the skeleton for what a particular partner or partners in general, or whoever you're preparing it for, like. Some people prefer a longer memo, some people prefer bullet points, some people prefer like case descriptions. But obviously, what you're going to be researching is different every time. Although I will say that I have in the past received and fulfilled requests for memos on particular subjects in the past. They needed to be updated, but they, saved a lot of time. So the point there is having, a DMS in which that kind of stuff is organized, or some other kind of repository, knowing whom to contact me to get something out of there and being able to search it in an effective and efficient manner. That's something of a process, although it's a small process. It's like a little weenie process. But it's still using those can be helpful, so you aren't flailing about trying to solve the problem yourself when there's someone who can solve it in a very short period of time.
Yeah, that legal judgment, that legal expertise, I think, is maybe what we're brushing up against right now. And it's true, there are areas where technology is sometimes a solution. An associate poring over a bunch of contracts, he's exercising legal knowledge, but the process of getting all those contracts reviewed and tallied and put into a memo obviously is time consuming. And I think that's where AI is kind of interesting for law right now as well, because we're starting to inch into that legal judgment space and testing it and pushing it, and seeing how well we can actually start chunking off some of those bits into process as well. I'm not sure that we're there yet, but that might be an area as well, kind of echoing Catherine's comments, where that legal judgment isn't always something you can replace, but that we're kind of trying to experiment with right now.
Well, you mentioned AI, so I'm gonna throw you a curveball here. So how one of the biggest challenges from where I sit with law firms and adopting generative AI specifically is all of the unstructured data that exists and what a mess it is at most firms for a number of reasons. First of all, attorneys are horrible at profiling documents and cleaning up after themselves in a DMS workspace. There's a lot of documents that were never used, drafts. There's just a lot of stuff there, and there's also barriers to getting to it, right? Because you've got it's inside this silo called the DMS, and you've got ethical wall boundaries that have to be respected, and that applies to any generative AI solution that a firm might want to deploy. But how it seems like what the work that you're doing here would be a real benefit to getting things predictable and curated. Is what is the relationship between this kind of work and a firm's ability to adopt generative AI solutions?
That
I
is a
could
really
just
good
jump in and
question.
say I think this
Yeah,
is where
I'm
KM.
gonna let Tim start on this one.
Hopefully, this isn't a dumb comment, but I'm a big advocate of KM, and have really become even more so since being in this role. I think they really fill a crucial role in that regard. And there's a reason that myself with my process background, I'm on the KM team right now. We deal with data, we deal with systems, we deal with the processes for identifying, for example, notable samples and precedents and making them available. I think that curation process is kind of where AI is, at least right now, never going to get where we need it to be, because it's sort of a garbage in, garbage out question, right? Like when you have really good data sets to point your tool at, you're going to get really good answers. But the tool's not going to know if something is good or not. You can't really get rid of a certain level of human judgment there. But I think that's where KM can fill that gap. Having folks like Catherine out there in the field who can kind of identify those documents and pass them along to people and look for efficiencies in that entire process. I think that's where that important gap is being filled by teams like KM, whereas AI is never going to get there, in my opinion.
Yeah, we are testing and evaluating a number of generative AI tools, some developed specifically for the legal market, some not. And I think the point made that Tim made about sort of garbage in, garbage out is important. So all of these tools trust your prompts, right? They're not going to question it. So I did, one experiment where I knew that there had been a certain number of cases on personal jurisdiction in the Supreme Court over the past X years. And I asked one of our tools that we were testing to identify and summarize them, and it didn't identify all of them. Let's say there were 4 and it identified 3. So then I said, summarize the 4 decisions by the Supreme Court, and it found the 4th. And then I said, summarize the 5, 6, 7, and it'll believe that there are 5, 6, and 7 Supreme Court decisions. I mean, obviously, they get more and more attenuated. It's just trying to find the best it can based on the content. So that's the kind of thing, so AI won't be able to understand, the depth. It won't be able to exercise the kind of judgment that lets you realize this case is not really about this. Maybe it will someday. But right now, that's not what I'm finding a good use case is.
Yeah, I mean, I see this. I have some theories on this. I think that the work, this sort of process work, is going to be absolutely foundational to firms getting their house in order. So it's many firms in practice areas and litigation included operate like the wild wild west in a lot of places, and things. Like you talk about the checklist manifesto in the book, which I'm a big fan of.
I was just thinking about that.
Right. So, cleaning up after yourself and removing irrelevant documents from the DMS workspace, profiling documents like you're supposed to, putting things in places where they're supposed to be. Process can drive those, and I think those are going to be very foundational to cleaning up law firm data, which is a prerequisite to really maximizing the capabilities of Gen AI solutions. So I think there's going to need to be more of what you guys are doing before we're ready.
Within the firm, we have a global knowledge bank, which serves all of our practices for litigation. It serves as a repository for noteworthy samples, meaning they've been reviewed and vetted. Guidance documents, teaching documents, various other things, forms, models. And and even the process of putting those in there and profiling them, as I just said, is a process, right? We have a naming convention. We have certain information that we put in the description because everything in the description is searchable. So, for example, I always put in the court, I put in the last name of the judge, and it takes a little while, but it means that you have good data that is searchable and that will give you, assuming, it's in there, what you want. And if it's not in there, people send it to me and I put it in there if I think it's of general application or would be useful to other folks. So if we aimed some kind of AI tool there, we would probably get pretty good results, I
Right.
think.
Which it's
That's the other thing is that AI tools are built into a bunch of the services we purchase, at least now, right? So Thomson Reuters acquired Case Text, which I've admired for a long time, and I think is really doing legal AI right. And it operates on a closed universe of the data that Thomson Reuters owns, which, by the way, includes anything on the public docket, including our own briefs. So you could, depending on how the tool's configured, you could use that to search our own material. One of the things I learned on this job is that a lot of the third parties do a really, really good job of coding our material and classifying it into different categories. So we're already paying for it, so why not use it?
Yeah, knowledge banks are so InfoDash is a legal intranet product, and that's typically where knowledge banks live. So we've seen a lot of them, and I think they're highly curated. And like you mentioned, the problem is they're fairly limited in scope. Right? There's just not.
Sure.
You got one template for each kind of document type. So, but it's like I've always wondered how firms that have like Mayor Brown, I would imagine, probably has close to 100 million documents in their DMS. Like, how do you clean that up? I think we're going to need AI's help
Yeah,
to use AI.
that's a really good point.
So tell me this: how? And I want to see an example. I think you have an example teed up. So we have listeners on Spotify, Apple Podcasts, but we also have a lot of viewers on YouTube. So for those that can have the benefit of seeing, we will, Catherine, if you're able to
Mhm.
show us one of these
Sure.
process maps and walk us through it, I think that would be instructive.
Sure. And for listening people, what I'm showing is actually what's in the book. And the book is, of course, available from PLI in bound form, but it's also available if your firm or organization has a PLI subscription, PLI Plus subscription, you can find it there. So if folks want to see it, they can. So let me do that. So this is one of the maps that's in the book. And so what we did is we took a typical commercial litigation and divided into a number of stages: initial case assessment and pleadings, discovery and summary judgment, pre-trial, post-trial and trial, and then judgment and appellate. There's also a mediation, arbitration sub-process, sort of, that, of course, can be entered into any time. There are two maps for this stage because what you do as a plaintiff and what you do as a defendant are totally different. But you can see that, you get, there are some pre-litigation tasks that everyone has to do, like, you have to send out a hold notice and preserve documents that might be relevant to the case. You want to evaluate the merits to decide if you really want to fight this or not. If you're firm, you're probably going to have to figure out if the budget and if there are any insurance policies that apply, and then the litigation starts with a complaint, possibly a motion for preliminary injunction and response. This is color coded for party. And then, there's sort of a limited number of ways to typically respond to a complaint, and they're all here, right? There's a number of motions you might enter into, and if all of those fail or any of those fail, you'll go to an answer, and then you'll go to responsive pleadings. This will make more sense if you're a litigator. But I would say like 9 times out of 10, this is how that first stage of litigation is going to go. So, there is some predictability. A lot of these, as Tim said, are decision points, right? You don't have to do any of these. You don't have to do all of these. But these are probably the inflection points at which you'll make a decision about where to take the case. And then I can also show you quickly what it looks like on our intranet, which is where it lives.
Yeah, that was going to be my next question as you're pulling that up is how and where is this used? Do
Sure.
you, new associates come in and use this as a training guide for how Mayor Brown's litigation department conducts business? Do your more
Mhm.
seasoned attorneys look at like who looks at this and how is it used?
I mean, lots of folks look at it. I mean, I teach a number of courses every year to new attorneys, and one of them is litigation resources, and this is always one of the resources that I highlight. And I also teach a 4-part series every year on litigation. KM tools and resources, and I cover this. And even if this is a little bit above your pay grade, I'm sorry, below your pay grade, it's certainly something you might want to direct your associates to. So here you can see, right, that we divided this into a number of stages, and I'll go to the stage I was just showing you. So this is what you just saw. And then each of these is replicated down here. So if you're dealing with a notice of removal and motion to remand, these are various tasks that would be that you would do. These are all if you're the defendant. And then, unfortunately, I can't show you because it's internal data. But if you click on one of these and go to documents, you will see a number of vetted samples that you can use. You don't want to copy and paste them, but if you have never done an opposition to a motion to remand or a notice of removal, it's really helpful to see what it looks like. There's also links to external resources, some of our service providers, right? Like Practical Law, stuff like that. And then supporting materials are internal materials. So, if we teach a series of courses every year. For the first year is called Litigation Nuts and Bolts. And so a link to the most recent recording of that presentation would be here. And then any other guidance documents we have that are applicable. This all is configurable. Things can be added, things can be removed. You want to do research it, or I'm sorry, review it once in a while to make sure everything is up to date and that the law is the same. But this is what it looks like, and it took a while to design, but I think it's a really good tool. I'm pretty proud of it.
So, what sort of adoption have you been able to measure? Like, how many people are using it, and what sort of what sort of variation? Like, how many of these cases are actually following this process versus not? Is that even possible to measure?
Not at this point. I don't think so. I mean, the best way I can do it is by if people ask a question that can be answered by it and I send them to it and then they don't come back,
Hmm.
that indicates that it's a success. So it's really more of a experiential or tool. It's more of an experiential evaluation that anecdotal.
Gotcha.
Exactly. It stems a lot of questions that might arise. If we think about sort of the maturity curve of KM 1.0 is solve the drafting problem. And one way of doing that is Global Knowledge Bank. And Catherine's taken us to, 1.2 or whatever with the process map, because now you're linking that to your actual practice work. It's not just finding a sample, it's finding where that sample fits in the life cycle of a litigation.
Right. All of these samples live in our global knowledge bank. So they could be accessed through the map. They could be accessed by searching the bank directly, however you want to do it. But I have had a number of attorneys come to me and say that this was really useful, or that they were happy they were able to direct someone to it.
Yeah.
So I think it's being used. Unfortunately, we just don't have the means at the moment to measure how widespread the use is.
Yeah. I have some ideas on that. Maybe we can talk about them offline
Sure.
from a technology perspective. So, what sort of advice would you give, someone who wanted to do what you're doing at a firm that's where this is new? As far as I can tell, this is. I mean, you're not the only one in the AmLaw that's doing, but it's not very common from what I've seen. And maybe, I don't know, maybe you can comment on that as well, like how many of your peers are doing this. But yeah, let's start there. How many people are doing, and how many firms are doing what you guys are doing that you know of?
I'll let Tim take that at
Yeah,
first.
I can't speak to the number of other firms that are doing that. I will say my sense is that KM and process generally seem to be more prevalent in the UK in particular, as opposed to in the US. But I couldn't verify that. That's anecdotal. What I would say, though, from my experience, having worked in process and legal, is that there's often a misconception about the investment and the return that you should expect. And I think the returns are certainly there, but the investment sometimes people, vastly undershoot. I mean, Catherine, correct me if I'm wrong, but putting together this map and the documents behind it, it was a 2 to 3 year engagement.
Yeah.
And it's fantastic now because it's there and everything. Like when you see it, it makes perfect sense. But it's not like you, as a partner, can just approach a process team and say, "Hey, I want something like that. Can I see it next week?" It doesn't quite work that way. I think setting expectations on level of effort involved is a key point, and setting expectations on the return to be expected is a key point as well.
Yeah, it took a long time. We released it stage by stage so that at least it was useful while we were developing it. But it did take a very long time. I have showed this at a couple of conferences, the parts I showed you, and I had a lot of people come up to me and say they'd never seen anything quite like this before. And I remember once at a conference, someone asked me, how do they do that? And my only answer, unfortunately, was, well, spend 2 to 3 years on it, which is, not, I think, what they were hoping to hear. I think, most firms now have some kind of knowledge management department or function. Some combine it with innovation, some don't. But if the degree to which they're doing this kind of process improvement work, I don't know. I'm sure there are firms doing process improvement. But I don't know, I feel like it's a little bit of a stealth thing right now. There's a lot of attention. I mean, everyone's talking about AI, generative AI, right? And innovation. But this is, a tool that can be applied to just about every process that needs improvement, which is pretty much every process, writ big or writ small, and can yield really helpful results. So I think all firms should be doing it if they
Yeah.
can.
Just one more thought to echo Catherine's as well. My sense is a lot of firms, when they think of process, they think of legal ops. Well, we don't want to set up a service center. It's not part of our strategy. So process has no place in our firm. And I think that's maybe short-sighted. But it is true. That's sort of, the center of the process world in legal seems to be the ALSIPs of the world, the legal ops outfits of the world. It's not so much law firms. It doesn't mean there isn't a place for it. It's just you have to think a little bit more about it.
Yeah. So when I think about, you mentioned ROI, I don't know if you use that term, but when I think about ROI and how you would demonstrate it, one area that would seem to make sense, but I could be wrong about this, is when you're marketing your services to clients and showing your maturity. Is that a path? Is that a way that you guys help? Do you do that?
Yeah, so this whole process map project actually came about because a partner was doing a pitch, and the client representative said, we had someone else come in here and show us a whole bunch of flow charts. Do you have anything like that? And so that's how it came into being. But it then grew from flow charts into this, interactive resource that you saw that gets you samples or guidance documents and so on. So we built on that. But I know that folks have both included the existence of the map as an example of innovation or process improvement, or just tools that their associates use for efficiency purposes in a response to a pitch, and sometimes have brought copies of the flowcharts themselves to client pitches. So it's been useful there.
Yeah. Ted, you might be more familiar with this as well, but for some banks in particular, where they have a lot of high volume, repeatable processes that rely on inputs from counsel, there's often interest among clients in a closer collaboration with a firm. How can we tie our processes together so we have, a shorter time to cash, for example, in a lending situation? these are some of the interesting opportunities that I think people don't think about all the time. Sometimes it's about efficiency or cost. People think AFAs and sort of how do you, control the financial aspect of it. But there's a client relationship aspect too that I think is the more interesting aspect for me.
Yeah.
We have a very successful global mobility and migration practice, and that's sort of a high volume repeat practice. Their job is essentially to help companies and organizations distribute workers around the world. So there's a lot of immigration forms that need to be filled out and visas that need to be obtained, and they have their processes down to a science, and they also have process maps that are located on the internet with links to specific forms and resources. So I think that's been tremendously useful for onboarding new associates, right? You just point them at that, and then they're able to do it with minimal guidance because it's so well laid out and produce the work product you need to produce very quickly.
Yeah, I could even see not so much with the work you're doing here specifically in the litigation department, but as clients are vetting your practices, right? Managing third party counter risk, ISO 27001, capability maturity model certification, all of that sort of stuff requires process documentation. And like you said, Tim, banks, for example, that are probably the largest buyer of legal services, fitting your processes in with theirs, if they're mature in that realm and you're not, it seems like that would cause some friction. So I could see, that being a great way to articulate ROI. And this is such a fascinating topic. I could literally talk about this. Like when you guys reached out and we discussed the work that you're doing there, you probably thought I was lying when I told you how interested in it I was, because not many people are. But so in the 16 years that I've been selling into legal, we've done business with 110 am law firms, so more than half. And I can tell you that I can count the number of times on one hand where I see, this level, kind of what you've outlined in the book. That doesn't mean it's not being done. I'm sure that it is. But where I see it is in firms that have really focused practices, labor and employment, intellectual property. You have big am law firms that's all they do. I mean, there's
Hmm.
probably 6 or 7 am law firms that pretty much just do labor and employment. So yeah, I've seen in firms like that, but in firms that have really diverse practice areas, I just don't see it as much. So for those that are interested in learning more, um, and we'll wrap up with this. Like, what would you guys? Obviously, the book, but the chapter's short, so you guys didn't. I mean, the book is massive, right?
Yeah.
But there's a lot of There are 22 chapters, so you can only go into so much depth. How would you suggest that someone interested in potentially pursuing this at their firm find out more?
I think that, one way to understand it is actually just to sort of do a trial run of it. So there are a number of tools that you can use. There's a really simple one where you map out a process as it exists, and then you just talk about each stage and what works and what doesn't work, and then rework the process. So you could take something fairly limited, right? Any kind of function within the firm. It could be a business function, it could be a legal function, and map it out, and then you get an idea of what we're talking about, is that processes can be mapped. If you think about it for just a little bit, and then they can be isolated into steps, and then you can consider each step, and maybe you'll decide that your firm is doing it exactly right. But my guess is that any process can withstand some kind of improvement. So maybe it's a little bit of a try it out thing. There are any number of consultants that would be delighted to be retained to help you with this, and maybe for a number of firms that's the right way to go. We have in-house experts, so like Tim, so that's been really helpful for us. And maybe that's another way to go, right? Is to decide to develop that as a function within the firm. So you have someone with the expertise to teach folks how to do it, and to understand how to sell it to the practicing attorneys. So not necessarily using words like Six Sigma, but other
Or
kinds of terms.
DMAIC or downtime.
DMAIC, or that kind of thing.
Yeah. Well, Tim, did you have any thoughts on that?
Just a 15-second thought as well. Yeah. Every firm has a developed business services offering, and almost all of those business services teams have to think about process to do what they do. So I think a lot of firms already have some process knowledge internally. It's just maybe a question of understanding how that works. I know the legal piece, we want experience in legal to be able to really apply that to the practices, but it's not like firms don't already have some process going on.
Yeah. Well, good. This has been an absolutely fascinating conversation. For those that are interested in, it's chapter 13 in the book, and that's the published by the Practising Law Institute, PLI. We will include a link in the show notes. And Catherine, if you guys are open to it and you can give me that PDF, we'll also include a link to that as well. So this has been great. I really appreciate both your time, and hopefully we'll see you guys around at ILTACon or KM&I or somewhere along the way.
Thank you. I enjoyed this a lot.
Yeah, awesome. Really did. Thank you, Ted.
All right. Thanks for listening to Legal Innovation Spotlight. If you found value in this chat, hit the subscribe button to be notified when we release new episodes. We'd also really appreciate it if you could take a moment to rate us and leave us a review wherever you're listening right now. Your feedback helps us provide you with top-notch content. Want to dive deeper into the world of legal innovation? Connect with us online at getinfo-.com, where you'll find additional resources and articles. You can also follow us on social media at getinfo- to stay updated on the latest news and insights in the field of legal tech and knowledge management. Once again, thank you for joining us today on Legal Innovation Spotlight, a fireside chat series hosted by Info-.